Hello, my name is Dan Farber, and I'm a member of the Berkeley Law Faculty. I want to welcome all of you to this celebration of the career of one of our most beloved colleagues, Steve Sugarman. We're here today to talk about Steve's work as a scholar, teacher, and policy advocate. We have a terrific group of speakers. I'm only going to talk very briefly in order to avoid cutting into their time. Unfortunately, I don't think it's likely that we will have time for Q&A. Unless you're speaking, please keep your audio muted. Otherwise, with an audience this size, we're going to get a lot of background noise and feedback. Thanks. Steve joined the faculty of Berkeley nearly 50 years ago. His move to Berkeley was an unusual start to an extraordinary career. He had never applied or interviewed for an appointment at Berkeley. At the time, he was playing a leading role with Jack Koons on our faculty on a major research project involving school equity. While he was out here to confer with Jack, he was unexpectedly approached by the dean, who offered him a job on the faculty. We should all be so lucky. And we should all be so lucky as to make the kinds of contributions that Steve has made to legal scholarship, to his students, and to public policy. We're going to begin with some overview remarks from Dean Chemerinsky and from former Dean Edley. The three next speakers will talk about Steve's scholarship, followed by a group of students who will discuss their experiences with Steve as a teacher. Then Steve himself is going to offer a few remarks, and my colleague, Mark Gergen, will close the event. So with that very brief introduction, let me turn to our Dean, Erwin Chemerinsky, for some opening remarks.
Thank you so much, Dan. In 1972, as a college student, I read the brilliant book, Private Wealth in Public Education, that Steve Sugarman co-authored. It documented the enormous disparity in school funding in the United States, even in the same metropolitan areas, because the reliance on local property taxes for education finance. It was the basis for litigation in many states, including Serrano versus Priest in California, which Steve participated as a lawyer, and ultimately led to the Supreme Court's decision, an unfortunate ruling in San Antonio Board of Education versus Rodriguez in 1973. Many years later, I met Steve at a conference where we were both speaking. I confess I was a bit intimidated to meet someone whose work I had so long much admired. But I found Steve to be so charming and friendly. Although we disagreed on the issue of the conference, school vouchers, he could not have been warmer, kinder to me, more down to earth. For the last 4 years, I've had the great pleasure of being Steve's colleague. He is the institutional memory and the conscience of Berkeley Law. As Dan mentioned, he's been a professor here since 1972. He twice served as associate dean from 1980 to 82, and again from 2001 to 2009. He served in many other administrative roles. Steve Sugarman is a beloved teacher of classes such as torts, food law, and education policy and law. He's published over a dozen books and countless articles, and I think it's fair to say no one is more influential in the field of education law in the last half century than Steve Sugarman. And he is truly a wonderful colleague. I'm so thrilled that this Festschrift was organized to recognize and honor him. I want to take a moment to thank Dan Farber and Mark Gergen, who played such a key role in organizing this, Sam Lamb and everyone on the Law Review, and Jenny Boyden for putting together today's program. Steve, no words can express thanks for all you've done for Berkeley Law and continue to do for Berkeley Law. Let me just say thank you on behalf of all of the deans who have served here since 1972, on behalf of all of your colleagues in these years, but I think most of all, on behalf of all of the students who had the great pleasure to study with you.
Thank you, Erwin. Our next speaker will be former Dean Chris Edley, an expert in fields ranging from education law to administrative law, who worked closely with Steve on a wide range of issues. Chris.
Thanks, Dan and Erwin. And of course, most of all, thanks, Steve. I knew of Steve's work, his early work, long before I knew how to spell Berkeley. Scholars generally associate Steve with his prodigious contributions in the field of torts. My permit is to give you some sense of of how he is so much more than that. His writing has been a central contribution to changes in public policy that have saved many billions of dollars in social costs and literally millions of lives. In academia, outside of STEM fields, this scale of do-goodery is rare. At the dawn of universities in the Middle Ages, the paragon of a scholar was a monk, a rabbi, an imam, a shaman, or the like. Religion or other spiritualism was the way to understand and shape the ways of the world. Today, Steve Sugarman is not a shaman, so far as I know, but like our inestimable dean, is a paragon of the public scholar. For example, Dean Chemerinsky has already talked about school equity, and his work litigating in the wake of San Antonio v. Rodriguez. So a callow Steve Sugarman joined this faculty in 1972, and the following spring, while I was a 1L taking constitutional law elsewhere, the US Supreme Court ruled 5-4 in San Antonio v. Rodriguez that education is not a fundamental right under the 14th Amendment's Equal Protection Clause. And therefore, the rational but inequitable school funding formula used by Texas did not violate the US Constitution. Now, most observers believe that this was the death of school finance litigation, which civil rights leaders viewed as a natural and vital step following on the vision in Brown versus Board of Education. However, Steve and our emeritus colleague, Jack Koons, brought a case under the California Constitution, which Steve argued before the state Supreme Court. Their victory in Serrano versus Priest in 1976 established that defeat in the federal courts did not mean death to the movement. It meant a change of venue. 3 decades later, relying on Steve's victory in Serrano, there had been successful school finance equity or adequacy cases in more than 38 states, millions of children, billions of dollars, unmeasurable nurturing of human potential. Okay, that's a great career. But listen to what he did after that. Here are just a few titles. California's insurance regulation revolution. Pay at the pump auto insurance, the vehicle injury plan for better compensation, fairer funding, and greater safety. Roles of government in compensating disaster victims. That he wrote in 2007, about 14 years after my service in the White House, where one of my responsibilities was overseeing FEMA's disaster budget and disaster policy. I wish that I'd had the benefit of his writing when I was in public service. Outcome-based regulatory strategies for promoting greater patient safety. Enticing business to create a healthier American diet. SALT, high blood pressure, and performance-based regulation. Innovative legal approaches to address obesity. How retailers could help us reduce salt intake. Should tobacco companies be required to reduce their number of customers? What about compelling product sellers to transmit government public health messages? The failed quest for equal educational opportunity, regulating education the way we regulate business. That's something he's working on right this moment. Rethinking collective responsibility for education. That's back in 1975. And it's a debate we're having right at this moment. Equal protection for non-English speaking children. A 1974 piece coming out, unfortunately, just at the same time as Lau v. Nichols, but presaging many of the battles we're still waging and litigating today. Accountability through the courts, a 1974 piece, Accountability for Education, that focuses on an issue that is, again, right now at the center of education policy debates as folks in Washington begin the run-up to the 5th reauthorization of the 1965 Elementary and Secondary Education Act. A tussle over accountability, how to make it enforceable, how to attach it to consequences. Steve was there 45 years ago. If Johnny can't read, get yourself a lawyer. Approving charter schools, the gatekeeper function. That's 2001, but that question of how to construct the gatekeeper function and use it to assure the quality of charter schools and fair competition with ordinary public schools is still in the middle of our school reform debates today. Education tax credits versus school vouchers. A little bit of that issue was hinted at last night in President Biden's address to a joint session of Congress. The promise of school choice for improving education of low-income minority children. That was 2004, but he'd done much writing, much scholarship on issues of choice, parental control, and bringing better education to poor and minority children for 2 decades before that was written. I could go on and say a lot, but I think one thing that we can conclude from this list, and this is just a sample of the 18 books and over 200 articles and chapters that Steve has written. One thing that's clear is that Steve is suffering from a couple of genetic mutations that have been much in the news lately. First, there is no reliable evidence that Steve ever sleeps, except during medical procedures and certain committee meetings. And here I want to discount the unreliable testimony of wife, children, and pets. He's contributed, so it's impossible that he sleeps. But second, and I think even more important, is a brain deformity that gives him not only a left hemisphere and a right hemisphere, but an extra hemisphere that's just for torts. There's thinking like a lawyer, but then there's thinking like a tortist. Duties, rights, autonomy, regulation, market failures, reasonableness, burden sharing, intention and negligence, agency and compensation. Steve brings these construct sensibilities and analytical tools to the good fight, and it is inspiring. When you're thinking about, I say to my colleagues, when you're thinking about something really difficult, which colleagues do you most want to bump into in the hall and chat for a few minutes? I'm talking, of course, about the before times when we had hallways. High on my list, the top of my list, is Steve Sugarman, and I'm sure that's true for many of you. Steve, I have to say that preparing for these remarks has made me question my own career choices. I've had some wins in public service and from academia. That I think gives me one more minute. I've had some wins in public service and from academia. 2 years after Steve and Jack won Serrano, I was working in the Carter White House. Treasury and OMB were gripped by the talons of deficit hawks and were recommending that Carter veto a budget-busting reauthorization of a child nutrition program, WIC. I met with Vice President Mondale and two of his aides to try to persuade him to join me in urging President Carter to sign the bill, provide the funding. At the end of the meeting, as I stood up to leave, the vice president put his arm around my shoulder and said, "Chris, you're a great American," which I'm sure he said to 100,000 people, but I was 25, so it meant a great deal to me. Steve, I've certainly tried to be a great American, but not on your scale. Instead of wasting 23 years teaching at Harvard, I should have been here at Berkeley, being mentored by you at what Howard Dean called the best law school in the solar system, made so by colleagues like you. Thank you for everything, Steve. Back to you, Dan.
Thank you, Chris. That was wonderful. Truly. The next three speakers will discuss Steve's scholarship. They've published fuller versions of their remarks in a Festschrift for Steve in the California Law Review, which is available on the Law Review's website for public access. All three of our speakers are acclaimed scholars in their own right, but it would take far too much time to list all of their achievements. So let me just begin with Bob Rabin from Stanford, a preeminent tort scholar who will discuss Steve's contribution to tort law.
Thanks, Dan. I'm very pleased to be participating in this Festschrift for Steve Sugarman. I was asked to write and comment on Steve's tort scholarship. But if I had taken that charge literally, it would have been a distinct disservice to Steve, because to his great credit, it is a central aspect of Steve's scholarship in this area that his work respects no confined injury-related boundaries. Initially, let me provide a bit of background on where tort law and scholarship stood in the mid-1980s, just prior to Steve's arrival on the scene. Judge Cardozo's 1916 landmark opinion in McPherson v. Buick Motor Company had opened the gateway to the possibility of a robust negligence doctrine, unshackled from the no-duty constraints that had burdened 19th century tort law. But notwithstanding McPherson, tort doctrine had largely stagnated for another half century. Then, beginning roughly in the mid-1960s, tort law came to adopt more expansive duties of due care and a mixed system of strict and risk-benefit liability for defective products. Hand in hand with this new era of doctrinal expansion, legal academics, ranging from scholars of a libertarian and corrective justice bent to an emergent law and economics movement, generated a lively ideological debate over the optimal systems of principles for assessing responsibility in tort. In the mid-1980s, coming at the tail end of this surge of doctrinal expansion and academic discourse, Steve launched his injury law scholarship by publishing, first as a lengthy law review article, and then in book form, a volume that was really a tour de force addressed to doing away with personal injury law, grounded in a thoughtful analysis of the shortcomings of tort in achieving efficacious deterrence, compensation, and fairness. In what would come to be characteristic fashion, Steve's critique ventures beyond doctrinal analysis to encompass relevant individual behavioral characteristics and regulatory deficiencies. In place of the tort system, Steve proposed, in doing away with personal injury law, a social welfare scheme covering medical expenditures and income loss without reference to the source of disability, funded through a combination of employer-based and expanded Social Security contributions. Injury prevention would be assigned to the regulatory system. A bold entrance by Steve into the world of injury law, hammering at its very foundations. The key to unlocking Steve's subsequent scholarship is to recognize that, as I just mentioned, it is unbounded by categorical pigeonholes. Let me identify and say something about 4 distinct pathways in his work: focused no-fault proposals, critical analysis of tort doctrine, historical perspectives on the tort system, and jurisprudential reflections. To begin with the first pathway, one finds focused policy proposals. Chris mentioned it in passing. In particular, Pay at the Pump, a volume devoted to an auto no-fault legislative compensation scheme keyed in its financing to mileage-driven and safety records. And this was not a one-shot affair in the world of focused policy proposals. Later, Steve would survey focused governmental compensation schemes for dealing with disaster relief in an essay on catastrophic loss, and home in on the 9/11 Victim Compensation Plan in an article that he and I co-authored in the Hofstra Law Review. A second pathway in his work led to critical analysis of tort doctrine, notably deconstructing the conceptually tangled assumed risk doctrine and effectively arguing for its superfluous character. Fast forwarding, Steve most recently proposes consolidation of the array of dignitary torts under a single conceptual approach based on generic responsibility for wrongful conduct that is highly offensive and causes significant harm. Still another, a third pathway, explores historical perspectives on the evolution of tort doctrine. In particular, a fine-tuned analysis in an earlier volume of the California Law Review addressing how tort law evolved in the 20th century. An analysis, again, by no means limited to doctrinal change. Steve, in characteristic fashion, grounds his wide-ranging discussion in normative developments in rights-based thinking, institutional transformation of personal injury practice, and evolving availability of insurance, among other factors. And finally, a fourth pathway leads to jurisprudential reflections, especially in a layered and singular analysis of the classic case of Vincent v. Lake Erie Transportation Company, involving the issue of whether damage to another's personal property under circumstances of necessity entails an obligation to reimburse for harm done. Should the ship owner, whose vessel has avoided the perils of storm-tossed waters by holding fast to and damaging the defendant's dock, be obligated to compensate? Provocatively, Steve rejects the majority scholarly view that compensation should be required. He posits a moral obligation to provide assistance to others in relatively easy rescue situations. What I have called four pathways in Steve's scholarship distinguishes him from most of the leading academics in the field since the latter half of the 20th century, some of whom have focused primarily on doctrinal analysis, some on moral theory, some on economic analysis, some on alternatives to tort. And in these remarks, I have passed by, for want of time, his ventures into comparative injury law and commentary on the restatement of torts projects. In Steve's work, one finds an embracing outlook that inspects every corner of injury law. Along the way, my own scholarly work has been greatly enriched by our collaborative efforts. 2 edited volumes of essays he and I co-authored on tobacco control. An edited volume of in-depth essays we co-authored on leading torts cases, published as Tort Stories. And as mentioned earlier, a co-authored law review article offering multiple perspectives on the 9/11 Victim Compensation Fund. Summing up, Steve has immeasurably enriched every dimension of intellectual and policy-based approaches to injury law. For that and our personal friendship, which by the way goes all the way back to student days at Northwestern, I have been the fortunate beneficiary.
Thanks, Bob. Peter Schuck from Yale, who teaches here on a regular basis now, will now talk about Steve's work on public health and other public policy issues.
Well,
Peter.
thank you. And thank you for inviting me and for putting this all together. It's a wonderful but inadequate tribute to Steve and his work and his impact. Time is short, and a lot of what I had to say with regard to specific scholarship that Steve has produced has already been discussed by others and is discussed in my article in my contribution to the California Law Review, Festschrift, and others. So I think what I'm going to do instead is to go meta and micro with respect to Steve's contribution. So let me begin with the meta. And that has to do with Steve's scholarly virtues. They are most remarkable, and that's because his approach to scholarship and to teaching are quite distinctive, perhaps not unique, but quite distinctive. He displays a number of scholarly virtues that I want to call attention to. The first is that he's driven by sheer curiosity, which presupposes that we are ignorant of many truths and that we must turn our meager resources, our intellectual and other resources, to trying to penetrate to those uncertain, often obscure areas that are so important but not fully understood. A second scholarly virtue is his passion for facts, wherever they lead, and that makes him both passionate and dispassionate in the sense that he can gain distance on the areas of inquiry in which he's engaged, but he's passionately committed to narrowing the area of uncertainty and ignorance. He's also skeptical about true believers who are infatuated by their commitments. He has many commitments of his own. That's evident in his work, the work that's been described, and some of that hasn't been described. But he is duly distanced from the passionate commitment to particular solutions or particular outcomes until he has satisfied himself and many other people of their truth. He has a determination to get things right, or at least as right as they're capable of being. That's a kind of fastidiousness that I think both marks his work and also tells us about some of the deficiencies of other work. So that's one meta observation about Steve, his scholarly virtues. Another has to do with the breadth and diversity of his scholarly work, and that I, as I say, I'm not going to mention because it's been so thoroughly identified, at least at a categorical level, but it's getting into the details that will impress any reader of Steve's work as to its high quality. But I want to mention a couple of areas of his scholarship that are, if not unique, rather unusual with regard to legal scholarship in particular. One has to do with the welfare state. His knowledge of the welfare state is very, very deep and very broad. It's not simply one particular aspect of it, or to the idea of expansive government to increase equality or due process or so forth. But he understands how the welfare state works in all of its complexity and diversity. And it's for that reason that he's able to detect the opportunities for reform that he's written about so well. Another area, and again, this is implicit in what others have said, but he is a great student of regulation, the process of regulation, the theories that animate it and that prescribe its possibilities and its limitations. And so in all the substantive areas that have been mentioned, there is a deep understanding of what is distinctive about the regulatory process and how it affects the substantive outcomes with which one or another reform is concerned. So moving from the meta to the micro, he is a gifted, much beloved teacher. Now, you folks who have been on the faculty with him for so long know this far better than I do, but in my relatively limited teaching experience at Berkeley, which consists of a series of 7 spring semesters up through last year, I have talked to students about a variety of pedagogical techniques and strengths and weaknesses. And Steve's commitment to his students has always been mentioned. And the quality of his teaching I've also observed when I participated in some of the seminars that he has put together. And I would also add, in my personal conversations with Steve, he has a deep concern for the quality of his teaching. And I've talked to him after class, before class, and he's very much committed to doing the best that he possibly can for his students. He doesn't just slough it off as one of those things that one does in order to proceed with the scholarly work that engages so many of us. Another micro observation that I have about Steve that I was able to discern despite my limited experience at Berkeley Law School was that he is one of those people that no great institution can do without. That is to say, he's an institutional man, institutional woman. That is, he's committed to the values of that institution, to its practical and its conceptual advances, and he puts in the time on committees and in hallways and in other fora to make the university function as well as it possibly can. And then there are a series of qualities that he exhibits, and I'm going to use mixed metaphors. I'm sorry? Oh, I don't know. I didn't hear what was said. There's a series of mixed metaphors, so I'm warning you ahead of time. He's a mother/father hen to his students. He's an architect of programs and of means for executing visions. He's a confessor for students who are troubled about one thing or another. he's an eminence grise of the law school. And I know this from discussing him with previous deans and with faculty. He is a kind of shadow dean. As I say, no great law school or institution of any kind can do without such a person. And then finally, the final micro observation is that he is, and it's also embedded in a mixed metaphor, is that he's a human hospitality tent. That is to say, Steve has been responsible for introducing me in my brief time at Berkeley to as many people as he can whom he thinks I might enjoy meeting or might enjoy meeting me. And he goes out of his way to entertain and to take people out to lunch and to, in a variety of ways, socially imbue the law school with humanity and generosity. So that's all I have to say outside of what I've said in the California Law Review. But I recognize the man and the scholar from everything that's been said so far, and I can only applaud the effort to bring this all out in the open where everybody can see it for what it is, which is a great institutionalist, a great scholar, and a great human being that has greatly enriched the school and people who participate in it. Thank you, Steve.
Thanks, Peter. As Peter just mentioned, besides being an eminent scholar, Steve is also a great teacher. 4 of our students asked for the chance to speak. Samson Lin, Haley McMillan, Raja Krishna, and Mia Tsoi will give us a student's perspective, adding to what those of us in the professoriate have already said. Sam.
Thank you so much, Professor Farber, Dean Chemerinsky, and Professor Gergen for organizing this event and inviting the California Law Review to participate. My name is Sam Lim, and I had the privilege of serving as editor-in-chief for volume 109 of the California Law Review this past year. And when we received the proposal to honor Professor Sugarman through volume 109's Festschrift, our membership voted for it overwhelmingly. The pieces were just published on our website, as Professor Farber mentioned, and I want to thank our amazing authors and the many members of the Law Review for their collective efforts. I'm particularly grateful to be part of this because I actually first learned about Professor Sugarman's work on school finance during my master's program in education policy through my advisor, Professor Luis Huerta, and because Professor Sugarman actually served on Professor Huerta's dissertation committee. In fact, I cited this in my application to Berkeley Law as one of the many reasons that I wanted to come here. Recently, I asked many of my colleagues on the Law Review to share some of their reflections on Professor Sugarman's impact, especially since many of them were his students. And shortly you'll hear from three of my colleagues, but others couldn't be here and they've asked me to share their comments. And graduating 3L Jasjit Mund said, "My law school experience would not have been the same without Professor Sugarman, who was my small mod torts professor. He's a faculty gem who is not only intelligent, but also kind and thoughtful. Thank you for all that you do for your students and beyond." Another graduating 3L said, "I had Professor Sugarman for torts my first semester of law school, and it was truly the best introduction to law school that I could have asked for. Professor Sugarman is not only brilliant, but kind and funny and interested in his students' success both in and out of the classroom. He taught me to always question the policies underlying the law and never to accept that the status quo is the right way to do things, just because it has always been done that way. Berkeley Law is so lucky to have him as a professor and as a member of the community. So Professor Sugarman, thank you for the unparalleled work that you have done to push for greater equity in the law, in education, and in health." And I'll now turn the mic over to my friend and colleague, Haley McMillan.
Hi, I'm Haley. I am a 3L and one of Steve's students. The first time Steve called on me in torts, my 1L year, he had a really easy question. He just asked me what my name was, but since it was the first day of school, I completely forgot it and had to think for a second. So it wasn't exactly a great start. And I won't lie, the first few weeks of class were intimidating. Steve never dumbs things down. And so we weren't just learning the case law. We were learning the case law and also why Steve thought a lot of it was dead wrong. but things started to click slowly. And I went to Steve after class one day with an idea about medical malpractice that he found really interesting. He said he'd get back to me with more thoughts, and I thought that would be it. But he later invited me to his office hours and told me he'd been thinking about my idea and that he'd emailed Dean Chemerinsky about it, and here's what they were both thinking. I haven't told him this before, but that moment was pivotal for me. This leading scholar took me seriously. He looped in another leading scholar, and then he followed up with me about what I had thought was an offhand comment. And that was really the moment when I started thinking, maybe I do belong here, both in this torts class and in law school. So when Steve asked me to be his RA in my 2L year, it was a no-brainer. In our meetings, we sat, we talked for hours, sometimes even about the research that we were doing. He's become not only a mentor, but a true friend. He is genuinely excited about good ideas wherever they come from, and he also pulls no punches in challenging what he sees as faulty ones. And he takes joy not only in the law, but in Berkeley law, from the Halloween parties and the potluck dinners that he throws for his small mod to the half a century he's spent strengthening the school. He also takes joy in his work outside the school on issues, as we've heard, from public health to access to education. And the last thing I want to say is that he takes joy in life beyond work, from his famous reviews of local restaurants to his loyalty to the Oakland A's. He's really shown me what it looks like to love what you do, to fight for what you believe in, and to have a sense of humor while doing it. And of course, he's taught me never to confuse the element of duty with the element of breach. So thank you so much, Steve. I can't think of a better person to be honoring today. And with that, I'm going to kick it over to my fellow student, Raja.
All right, thank you, Haley. My name is Raja, and I am a 3L as well. Like Haley, I was in Professor Sugarman's small mod, known affectionately to its members as the Sugar Mod. He inspired me from day one, from the first day of class, to truly appreciate how deeply our society has been shaped by the ways we've structured our legal system, and therefore to not be afraid to question that legal system. It seems like a theme that's been emerging today. During my 2L year, I was called for jury duty. I was the last potential juror in the pool, and if I wasn't selected, another pool would have had to be convened. As it happened, the case involved a tort. When the plaintiff's attorney learned that I was a law student, he asked me what I thought about the current state of tort law, and I took the chance to reflect on some of Professor Sugarman's ideas about no-fault insurance, strict product liability, and intentional torts. Needless to say, I was promptly dismissed from the jury pool, but not without a lengthy comment from the judge praising Professor Sugarman's scholarship and the wide-ranging influence of his ideas. I've also been lucky enough to observe a sliver of Professor Sugarman's relationship with his family, in particular his granddaughter. Many of you might know that my classmate Will Leong and I wrote a series of humorous law school songs during our 1L year. But you may not know that Professor Sugarman specially commissioned one for his granddaughter, as he was already in the process of working on a musical with her about none other than tort law. He wanted us to create a song about Injuristan, a fictional land where tort victims would not have to worry about insurance coverage in order to be taken care of. Every now and then, he'd approach us after class and give us notes or ask for an update on the songwriting process. And going through the creative process with Professor Sugarman is one of my favorite memories from law school. It makes me smile to this day. So Professor Sugarman, thank you for dedicating your career to imagining and building a more just world. And thank you for making us feel welcome at Berkeley Law and in the Bay Area by inviting us into your home and into your life, and for showing us what it means to bring passion and love into everything you do and into all of your relationships. Now I'll turn it over to my friend and colleague, Mia.
Thanks, Raja. Hi, Professor Sugarman. I wasn't fortunate to have Professor Sugarman for a doctrinal class 1L fall. But even before I came to law school, Professor Sugarman's reputation preceded him. As others have mentioned, Professor Sugarman publishes a food guide listing all of his favorite restaurants in the area. And as a Bay Area native, I cross-referenced his food guide with my family's favorite restaurants. consistent with the rest of Professor Sugarman's oeuvre, it checked out. And so when there was an opportunity to take a small seminar with Professor Sugarman 1L spring that included lunches catered from restaurants Professor Sugarman would select, I took it. Now suspend your disbelief and imagine that what I loved most about the class was the topic, public law and policy, focusing broadly on regulation. It was an intellectual feast. Each week, different guest speakers came from across the country and the world to talk about regulation in a wide array of substantive areas. Professor Sugarman was in his element. And the unique guest speaker format of that class immediately impressed upon me the level of camaraderie and mutual respect that Professor Sugarman has with experts from such a wide breadth of fields. I had a similar experience working with Professors Farber, Gergen, Morin, Rabin, and Schuck editing the Festschrift that we're celebrating today, all of whom clearly cherish Professor Sugarman, and all of whom with whom he easily engages despite the diverse array of substantive areas those professors represent. I'm fortunate to have continued to learn from Professor Sugarman in subsequent years. He's weighed in on questions I've had in other classes and provided insight on a paper I worked on that dealt with EU regulation. And I'm grateful that I've continued to benefit from Professor Sugarman's food recommendations and even had a chance to contribute a few of my own. In the age of COVID, we've switched from restaurants to recipes, but it is no less a pleasure to learn what Professor Sugarman considers good eating. What I've learned from Professor Sugarman, above all, is a way of being, to approach any subject with excitement and curiosity, and not to worry if it makes sense to anyone else. To do what you think is fun, and you will be good at it. Thank you. And now I'll hand it back to Professor Farber.
Thank you. Like any good advocate, Steve has reserved some time for rebuttal. Unlike the courts, however, I do not have a red light that I will turn on. Obviously, even if we run a little past our original deadline, we all want to hear what Steve has to say.
Thanks so much to the California Law Review for publishing these very generous essays in this Festschrift issue. And thanks to Mark and Dan for organizing this event and recruiting such wonderful people to make contributions, my colleagues and former students. They've said very many embarrassing things about me. If you notice this red blushing on me, that's the reason. I want to thank the students who spoke today, especially. It's very kind of you to come to this occasion and say such nice things. To my past research assistants, those I've collaborated with on scholarship over the years, and to all those I've had the good fortune of having in class, that somehow managed to get them to engage the materials in ways I'd hoped. We law professors at Berkeley Law have the best job I can think of. We work with stimulating colleagues and students. We pick the topics we want to write about. As Mel Eisenberg, my distinguished now retired colleague, once said, I write and teach for free. It's just that I charge a lot to the regents to grade exams. Some of you may know I'm a Tom Stoppard groupie, and I've been currently listening to the new on Audible and the new biography of Stoppard. It's some 800 pages. Only a groupie like me could think that's too few. One of the things along the way, Stoppard remarks, taking a line from Hosea Berlin, that you can try to know nearly everything there is to know about one thing, or know a bit about many things. Those of us in the legal academia tend to break into those two groups, some of whom become the most important leading scholars in their field, whatever it is, and they spend their whole career working in that field and be deeper and deeper more and more insightful, more prominent. I think I've been in the latter category where I'd like to know a little bit about a lot of things and move around to new topics as they get my attention. Maybe this makes me a dilettante, but it has had one great advantage. It's allowed me to co-author work with many colleagues. Bill Clune, Arnie Cantor, David Kerp, Ron Whitus, Bob Mnookin, Lou Friedman, John Fleming, Ira Ellman, Paul Minorini, Jeff Hennig, Bob Rabin, Merit Sandman Erickson, Caitlin Boucher, Ann O'Leary, Gillian Lester, and Ariel Parat, all of whom I've co-written things with and gained a great deal from. But most importantly, of course, is my co-authorship relationship with Jack Koons. Jack was my mentor at Northwestern. He's been my mentor ever since I've been here at Berkeley. We've written 5 books and countless articles together. And he's really made my career, whatever it is most importantly attributable to him. His insights and inspiration and support and continued collaboration has been quite incredible. There was some talk about my teaching. I just want to mention I've had a chance to co-teach also with a number of colleagues. Jan Rubenfeld, Elmer Swift, Angela Harris, Ira Ellman, Maris Ash, Molly Van Houweling, Mark Udoff, and Ariel Parat. I always learn things when I cooperate with others in my teaching. I learned some technique strategies and I learned substantive things. And for that, I'm very grateful. Berkeley has been incredibly good to me, beyond what I could have imagined when I came here. First through the Childhood Government Project, which Bob Mnookin ran when I first came to Berkeley. Then through the Forum on the Family that Marianne Mason prompted us to create. Then through my service on the Campus Budget Committee, where I work with Pam Sanderson and under the chairmanship of Meg Conkey, among others. And through my 2 stints as Associate Dean under Sandy Kadish and then under Chris Edley. I've been blessed with getting to know so many wonderful colleagues. Berkeley has also allowed me to do sabbatical research in other countries, England, France, Italy, Japan, and to teach in other places, Columbia and Tel Aviv, helping me to appreciate that we can learn a lot from the way other countries run their legal systems, to say nothing of the pleasure my family and I have gained living temporarily away from home. My website divides my published work into a number of categories, and the speakers today spoke about different categories. I want to close briefly to say that I think, however, there is one theme that runs through a great deal of my work. It's that we as a society can do a lot more to improve the lives of the have-nots in our nation, both by enhancing their material well-being and also by empowering them to have considerably more control over their lives, whether it be able to decide whether to take paid leave from their work or where their children attend school. These are themes upon which I have been working and hope to be able to continue to work as I finish up my career at Berkeley. Yes, no, I'm not retiring yet. And lastly, as I close now, I want to express my love and appreciation for my wonderful wife, Karen Carlson, who has tolerated me for 50 years now, 50 splendid years, so far as I'm concerned. Thanks very much, my love.
Steve, thanks for those thoughts. I'm now going to turn the baton over to Mark Gergen, our Associate Dean, to bring the proceeding to a close. Mark.
We're running over, so I'll be very brief. Thank you, Steve. Thank you, all the contributors. I want to leave everybody with a very happy thought. This August, a small group of Berkeley students are going to get together in a classroom, and Steve is going to teach them torts. I hope everyone's healthy and does well. Thank you for being here.